More now in our law and justice lead with a federal judge ordering former Trump advisor Steve Bannon to report to prison by July 1st. With us now, former Trump attorney Jim Trusty. So you just heard, Jim, Sarah Murray report that a judge has ordered Bannon to report to prison by July 1st for a 4-month prison sentence. What's your reaction in general?
I mean, not surprised. I heard her say that the defense team was surprised. Maybe they were, maybe they weren't. Maybe they at least said they were surprised. But look, there's a lot of statutory and case law overlap that basically talks about staying a sentence and keeping a person out of jail while they are pending appeal. It's very uphill. And you have to basically convince the sentencing judge that there's a serious error that they're likely to win on appeal. The D.C. Court of Appeals just shut that down. The history of these contempt cases with the Supreme Court's not particularly favorable for Bannon either. So that all kind of conspires to make it a pretty easy legal ruling that he's not going to be able to stay out anymore.
Yeah, let's talk about that because there is an obvious immediate precedent. Peter Navarro, another former Trump White House aide who also was sentenced to prison for contempt of Congress, tried to appeal it, appealed it all the way to the U.S. Supreme Court. Chief Justice of the United States, John Roberts, shot it down. He's in prison right now. Given that, and the fact that Navarro was actually a presidential aide as opposed to Bannon, so he had more of an argument, I guess, in terms of executive privilege, is there really any path for Bannon here?
Well, there is, but I wouldn't say it's a great path. You know, obviously filing a petition for certiorari, trying to get the Supreme Court interested, is a far cry from having them accept the case and deal with it on the merits. It's even harder when you're talking about a stay. So if there's a hope of an emergency motion to the Supreme Court, which there may well be, that's going to actually undo this ruling today, I think that's unlikely. You might get to the merits in the Supreme Court eventually. There's some weird little issues about executive privilege in terms of, you know, how you actually know that you're supposed to use it and supposed to invoke that privilege. So a lot of kind of, you know, nuanced stuff there, but I just don't think that this is the case that's going to make it. I think it's going to probably die out with the Court of Appeals.
Let's talk about something having to do with the former president, Donald Trump. New York police are trying to revoke Donald Trump's gun license now that he's a convicted felon. He's forfeited 2 weapons already. I think when he was indicted, he did that. There's a third listed on his gun license that was lawfully taken to Florida, where he lives. If he still has that third gun, he could theoretically be violating laws in Florida and New York, and not to mention federal law. I mean, I know he has a sympathetic ear in the governor of Florida, but is this a concern as a former attorney for Mr. Trump?
I think you'd have to talk to him a little bit about whether it's time to put it in trust or give it away or sell it. But, you know, this is a couple of things. One is this is probably the most efficient moment of New York licensing in the history of licensing. Like, right. I mean, it's kind of like they're just getting around to Capone. But now they've got Trump saying
the government can be pretty efficient when it wants to be.
Well, I think that's this case. The other thing, I mean, honestly, when I read the story, my first thought was, you know, when you're on the highway and there's like a wide load tractor in front of you with a prefab house, I can see Trump Tower leaving New York at this point. Like, he's got to just realize it's so incredibly hostile in Manhattan that, you know, of course they're going to be efficient on this thing. So at the end of the day, you know, I don't know that President Trump is known for packing heat too often. But I would say the safest route in the long run is don't give a creative prosecutor any sort of avenue to say that he's possessing a firearm as a felon.
So you worked on Donald Trump's classified documents case. You don't anymore. Now Judge Cannon is once again ripping up the court schedule for the case in Florida, saying she's going to hold a hearing on the legitimacy of Jack Smith as special counsel. She's going to allow outside groups, not just the plaintiff and the prosecutor, the defendant and the prosecutor. She's going to allow partisans from outside the case to join the argument. Is that normal?
Well, we call partisans amicus briefs, right? I mean, but look, I think this is, you know, there's a lot of people that are already kind of preemptively throwing stones at her, saying she's overmatched, she doesn't know what she's doing. The reality is she's doing stuff that's actually pretty typical to federal practice for a non-incarcerated defendant. And the fact that she's having hearings instead of ruling on the papers should be something that whoever the person is, but particularly a presidential candidate, we should welcome that. We should say, let's air it all out. Let's have the public and the attorneys there airing it out. The only thing that's unusual about all the stuff that I've heard is, in fact, having amicus brief participants do argument as opposed to just submitting the briefs. You could read the tea leaves and think that might show that she's kind of struck by the amicus filing by former Attorney General Ed Meese and some folks with him that really question the whole constitutionality of the special prosecutor statute.
Okay, a Meese reference if you're playing Ed Meese drinking game at home. Drink. Jim Trusty, thanks so much. Always good to see you.